Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're going to continue our video series designed to educate our viewing audience. We're going to talk a little bit about custody and parenting time, so please subscribe to our channel. You know, in every divorce with children, while we deal with the issues regarding property settlement and asset division and perhaps alimony, we're also going to talk about custody and parenting time. Now, those are the main issues of focus with respect to the children. The court's going to have to determine ultimately who's going to have the decision-making authority regarding the kids on major issues and who ultimately are the kids going to live with. The first thing that I discussed, the decision-making regarding major issues with the kids, that is what's called legal custody. But where the kids actually sleep, where they live most of the time, that's your physical custody. And the court has to make decisions about who's going to have what. Who's going to have legal custody, who's going to have physical custody. And they don't necessarily follow each other in the same way. The parties might share the decision-making, and that's called joint legal custody. But they may not share the physical custody. That is, the kids could primarily live in one place, while the parents share equally the decision-making. And really, that model makes a lot of sense, and the courts do favor that model. Even if they award full custody to one person, often they will split the legal custody so that both parents can weigh in on the raising of their children. Now, even if the court grants custody to one person because the other person is wholly undeserving of custody, the court will still grant that person parenting time if it deems it to be in the best interest of the children. And the presumption is going to be that the non-custodial parent's going to get visitation. They're going to get time to see her kids. The only time the court will say, you know what, no parenting time either, is if the court determines that at that moment it's detrimental to the children to have that exposure. Maybe the person we're talking about is, on death row. Maybe the person we're talking about is a drug addict and an alcoholic, and having the kids spend time with them is just going to hurt the kids psychologically and who knows in what other way. In that circumstance, the court may very well suspend the visitation or the parenting time until things get better. But understand one thing. Even if the court suspends the parenting time until further order of the court, the idea is that when the condition that the court deems dangerous is removed, that person can now come before the court and say, okay, I was hooked on heroin before and that was dangerous, so you removed my parenting time, but now that condition is over, and therefore I want an opportunity to spend time with my kids. And you can well expect that the court will, upon showing proper proof, give that person the opportunity to sort of be reintroduced to the kids and have an opportunity to have some parenting time and spend some time with their children. If you have any questions about that, reach out. We'll be glad to help you out.